Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nonni.
And I'm Jaeson Homola.
And this is
It's No Accident. One thing that a lot of our clients don't realize about our law firm is that we actually handle cases not only in Florida, but we also handle cases in Georgia. Tallahassee sits about 20 minutes from the Florida-Georgia line. So, over the years, we've gotten quite a few Georgia cases. I myself am not licensed in Georgia. I'm not licensed to practice law in Georgia. However, Mark, over here with his big brain, does have a license to practice law in Georgia. So pretty much any case that comes into the office is going to go through Mark, especially if it gets into litigation and lawsuit needs to be filed. So it's, Mark spends a lot of time talking to potential clients about, misconceptions that they might have about, their case being in Florida and things that they've heard about cases in Florida and how things are different in Georgia. And it can have some effects on, the recovery that you get in a case. It can have effects on how the medical bills get paid in on an auto case and a premises liability case, pretty much any case. And what that stems from is just basically the fact that it's a completely different state and they have completely different laws. So most of the laws that we have in Florida are going to be different than what you have in Georgia. So can you kind of provide us or our viewers with what some of the major differences that you see or you come across with regards to Florida and Georgia law, and maybe in the context of like a motor vehicle wreck?
Sure. No, absolutely. Yeah, like you said, I mean, it's something that comes up a lot, and a lot of times when I'm talking to people and explaining the differences, people who are just more used to Florida and the way Florida law is, you get kind of surprised when you hear about some of these differences that are kind of unique.
I get kind of surprised by some of the differences in the laws. But
yeah, there are a lot. I mean, I guess I'll start with one similarity, which is only, I guess, as of the last few years. I mean, forever, one of the biggest difference I would tell people was the statute of limitations was different. It used to be, right? It used to be 4 years in Florida and only 2 years in Georgia. So that was always a big deal to keep in mind, because obviously if you miss the statute of limitations date, you're done, right? But as we know, like as of 2023, Florida changed theirs to 2 years, so now it's the same, right? So that's one big difference that doesn't exist anymore. I'd say from the car wreck, from just like a standard car wreck case perspective, probably one of the biggest differences is the way that Georgia is with auto insurance coverage versus Florida. And some of the stuff we talked about a lot over the years that we've been doing this in terms of, like, number one, PIP coverage, right? The personal injury protection coverage, or PIP. That's Florida's no-fault system, right? And that's what, basically is there to, if you get in a wreck and you get hurt, no matter whose fault it is, in Florida, you have to have the PIP, and the PIP pays $10,000 towards the medical bills, right? Or lost wages. But that doesn't exist in Georgia. Or I guess I would say it's not mandatory. Like Florida, it's mandatory. You got to have PIP. Georgia, I believe you can have it if you want, like as an add-on, but you're not required to have it. So,
And if you've got health insurance, there's really not.
Why would you? Yeah, exactly. So 9 times out of 10, or probably more like 9.9 out of 10 times, if I have a Georgia case, there's not going to be any PIP involved, which is, kind of a big difference just in terms of, like you said, if it's, if the person has health insurance, it's probably not that big of a difference because the health insurance is there to pick up the medical bills. But if the person doesn't have health insurance and they don't have PIP, it's, there's no PIP. That's a big difference because there's, nobody that's paying these medical bills as they're racking up, until ultimately we hopefully get a settlement 6 or 10 months down the road to go back and pay those medical bills. Right. So then obviously causes issues with, people being stressed out about medical bills going to collections, even though it wasn't their fault, kind of thing, and that.
Well, not only that, but I guess keeping an eye on what those medical bills are at, compared to what the limits of the at-fault party's insurance is, because, the way medical bills are nowadays, it doesn't take long to rack up $20,000 in medical bills. And correct me if I'm wrong, but it's $25,000 is the
minimum.
The minimum for auto insurance in Georgia.
For bodily injury, right?
Yeah.
Exactly. Yeah, exactly. You're right. So you want to kind of, like you're saying, you want to keep an eye on the medical bills to make sure, you don't end up in a case where the client has $50,000 in medical bills and there's only $25,000 worth of insurance that you can get from the other side, right?
Sure.
And there's not enough to go around. It obviously creates problems, but yeah, I mean, I'd say that's the other, in terms of a car wreck case and auto insurance differences between Florida and Georgia, that's the other big difference in Georgia is that they do have required bodily injury coverage, right? Which is, I know, something we always, not always, but I've often talked about that Florida is lacking. That's a problem, right?
Right.
That in Florida, you're not required to have bodily injury coverage. And, again, obviously the bodily injury coverage is what, like if you're driving and you're at fault and you cause a wreck and you hurt somebody else, the bodily injury coverage is what pays the settlement to that person.
Right.
Right. So like all the cases we take that are car wreck cases, if we get a settlement from the client, not always, but usually it's coming from the defendant's bodily injury coverage. Right. And in Florida, you're not required by law to have it. Well, I think we've said it before, it's only like one of two states, I think, in the country.
Yeah, and it creates issues too because, we'll have a client, a potential client that comes in and we'll talk to them and it's a clear liability wreck and they'll give us the crash report or we'll get the crash report and it'll say that there is insurance coverage on the vehicle that caused the wreck, but that's not the end of the story, because at that point then we have to go get in contact with the insurance company and verify that not only that the coverage was in place at the time, but they had bodily injury coverage on the policy. Because if that bodily injury coverage is not there, then you're left with making a claim against the personal assets of the person that caused the wreck. And, I don't think it's any secret, and if you don't believe this, I'm here to tell you that the case is that if there's someone driving around that has an auto insurance policy that doesn't have bodily injury coverage on it, they don't have the assets to go after it. It's not going to make financial sense for you to go after them.
Exactly. Yeah, it'll cost more than you'll ever get. You'll never see a penny.
Yeah.
Right.
Yeah, I mean, you can, and there's people that do it. There's attorneys that do it. But a lot of times it's just not going to make sense.
Right. No, exactly. And so that's one benefit of Georgia is Georgia does have the minimum of, like you said, $25,000 per person, $50,000 per crash. The minimum amount of bodily injury coverage you're required to have by law in Georgia. So at least, not 100%, but more so, like if you get in a wreck in Georgia and the other person who caused the wreck is from Georgia and has a Georgia auto policy, almost 9.9 times out of 10, you can rest assured that there's going to be at least $25,000 worth of insurance to pay for your medical bills and your injuries and your pain and suffering.
Absent some sort of coverage issue,
Right.
or they didn't pay their policy or something.
Yeah, exactly. Or like this was, an excluded driver who snuck out and took the car out when they weren't supposed to, or something like that. Right.
So that is nice about Georgia
Yeah.
because there's not that extra step of sometimes we have to wait sometimes we wait like 20 or 30 days to figure out if there's bodily injury coverage. And if we find out on a Florida case, and if we find out there's not bodily injury coverage, that's a tough phone call to have with the client.
Right.
Call them and be like, yeah, look, I know the other party's at fault. I know you didn't do anything wrong here. There's no bodily injury coverage.
Right.
And if that's the case, we'll do a quick assets check on the person just to make sure that it's not like somebody that made a mistake and just didn't have insurance on their vehicle or didn't have bodily injury coverage. But I would say about 99.9999% of the time, there's not going to be the assets there to go
Right,
after.
exactly. And so basically, like you said, it's tough because it's like we're basically telling the client, look, the case is over. Right, there's nothing we can do. So
Unless they have uninsured motorist coverage. So
right.
PSA, get uninsured motorist coverage if you're a driver in Florida.
I know.
Look at your policy, make sure you've got it.
I feel like I say that all the time to everybody who will listen to me, and you know what I mean.
Right. I've had clients. I mean, and I know you've had this situation in the past. I have too. I've had clients before that, they get injured. I handle their case. There's a low amount of bodily injury coverage or no bodily injury coverage. And I tell them, I'm like, look, I know it's not going to help you this time, but you need to go get uninsured motorist coverage on your policy. And lo and behold, that person, 5 years down the road, they get into another auto wreck, and them or their family member that's on the same policy, and they come in, and I'm like, remember last time I told you to get that uninsured motorist coverage? Did you do it? No.
Right.
So,
yeah, I know. It's frustrating.
Yeah.
I've definitely had that too, and it's, all you can do is tell them. I guess you can't make them.
No. Yeah, you can lead the horse to water. You can't make them drink.
Right. So, but yeah, so those are from auto insurance perspective. Those are probably the biggest differences between Georgia and Florida. And I guess going back to the personal injury protection, this is kind of in the weeds a little bit, but the fact that Georgia doesn't have the mandatory personal injury protection coverage means that there's no what we call like the permanency requirement or the permanency threshold.
Right. And that is kind of in the weeds, but it's a huge deal if you're taking a case to trial, for sure.
Right, exactly. And so what it basically says in Florida, the law says, the PIP law basically says that in order to get any money for pain and suffering, you basically have to prove that you have a permanent scar.
Yeah.
You, like disfigurement, mean like you lose part of your body, right? A permanent scar or a permanent injury, right? And so normally in the like typical car wreck cases, you know, I mean sometimes it happens, but most of it's run-of-the-mill case, the person's not disfigured and there's no permanent scar, so it comes down to the permanent injury thing, right? And that's something that we've dealt with, and we know lots of other attorneys we've talked to over the years who've had a tough time with it at trial, right?
It's always a battlefield at trial.
Yeah, and that usually ends up being like probably one of the biggest points of contention at trial is us trying to prove to the jury that the client has a permanent injury and the other side trying to disprove that essentially. And then, literally so at a trial on the jury form, one of the questions would be, does the plaintiff have a permanent injury? And if the jury says no, then you don't get any money for pain and suffering or inconvenience or, any of that stuff. Like you're entitled to your medical bills and lost wages, and that's basically it,
Yeah. So all of the pain and suffering, mental anguish, inconvenience, loss of enjoyment of life, all of those, not what are called non-economic damages that people tend to think about when they have a personal injury case. In an automobile wreck in Florida, if you can't prove that you have a permanent injury and the jury finds that you don't have a permanent injury, you literally don't even get to make you don't get to make those arguments. The jury doesn't even consider those arguments, and they don't put a value on those because there's no permanent injury.
Mm-hmm, exactly. And so that's definitely, I guess another advantage of Georgia, so to speak, in terms of if you end up going to trial in Georgia, you don't even have to deal with that issue, the permanency issue.
Right.
I mean, it's obviously, if you have a client with a permanent injury and you're going to trial, it's probably still good evidence we would want to put in front of the jury.
For sure.
But it's not, it doesn't make or break whether or not your client gets any pain and suffering damages.
What it comes down to is it's not another hurdle that we
Right.
have to get over because, I've had cases before where my client had a broken kneecap or, they separated their shoulder and needed shoulder surgery and, they've got a scar on their shoulder and it's a pretty decent scar and, you'll have the defense attorney arguing, well, that's not a significant enough scar to qualify for a permanent injury.
Right.
Or the loss of range of motion in the shoulder after the surgery got back to within 2 degrees of what's normal, so that's not considered significant enough to be a permanent injury. And you've got your client over there that's like, well, I used to be able to bench press 250 pounds, and now I can bench press 125. Like, I'm here to tell you that this is an issue for me. And they're like, well, sorry, we don't think you have a permanent injury.
Yeah, that's tough.
So, but yeah, that definitely, I'm glad you brought that up because that always becomes an issue in the cases.
For sure. And I guess just without going too far down into the weeds, in terms of like a premises liability case, like slip and fall, trip and fall, generally I would say, I guess, those cases are tough, I would say, whether you're in Florida or Georgia, right? There's plenty of times where, I guess really what I'm saying is, we see this all the time where the common perception is you slip or you trip and fall at some store or establishment. People are like, oh, well, I fell on their property, so therefore it's their fault, right? And it's never that simple. And even in Florida, it's more complicated and it can be difficult to prove, the defendant was at fault and be able to get a settlement for that kind of case. But I guess what I'm trying to say is in terms of difference between Georgia and Florida, I would say those cases are even harder in Georgia. And again, without getting too deep into
we've talked about this before. It's,
they've
got there's some wacky court rulings up there that, they don't make that much sense, but.
Right, yeah. And in terms of, without getting too much in the weeds, there's a lot of decisions up there that just make it a lot harder where you have to have, I'd say, stronger, better evidence in Georgia for a case like that to be viable without essentially getting thrown out of court. Right. And it really, I guess what it is there's a lot of stuff in Florida, like there's a lot of evidence in Florida where like
circumstantial sort of evidence.
Yeah, there's circumstantial or just stuff where like, in terms of like, that would be more comparative negligence, right? There's like arguments in terms of like comparative negligence, meaning where the defense is trying to argue that it's somehow my client's fault why he or she tripped or fell or slipped and fell, right? And in Florida, those arguments, are valid, but it doesn't mean your case is over and gets thrown out of court. It just means
It means the jury's going to make that decision.
yeah, the jury can put some of the blame on the plaintiff and some on the defendant, whereas those same arguments in Georgia will just get the case completely thrown out of court on summary judgment. You don't even get to go to a trial.
Right. The judge will make that decision for
Right.
you. Yeah.
Yeah.
So, and I think that's what I've seen over the years talking to you and, just asking you questions about what the differences are between the Florida law and the Georgia law. There's some things in Georgia that I'm like, well, that's a lot more beneficial in Georgia than it is in Florida. But then on the flip side, there's some things that I look at and I'm like, whoa, and this wouldn't even be a case in Georgia, and it is a case in Florida.
Right.
So,
Yeah.
and it's funny because, we're literally 20 minutes from the border, and, you go across that border and something happens that would be a case in Florida, but is not a case in Georgia.
Yeah, it's crazy.
Or vice versa.
Right.
Something happens in Florida and, you don't have a claim here, but you have a claim in Georgia just based on what the laws or the case law is there.
Yeah. So it's kind of a mixed bag, like you said, some stuff's better in Georgia, some stuff's better in Florida. I would say one thing though that's more, not 100% universally, but generally I'd say better in Florida than Georgia is just the speed at which cases move through the litigation process, right? Like how
Yes.
basically what I'm saying is like from the day you file a lawsuit, how long does it take to potentially get to a trial date? For the most part, there are some exceptions in Georgia, but for the most part in Georgia, it's painfully slow. It's like molasses. It's so slow. Whereas in Florida, pretty much every court I practiced in Florida is at least good in terms of at some point once you get into the case, you're going to get an order scheduling a trial where you actually have a trial date, like a week. Your case is set for trial this week, and then you have a bunch of deadlines based on that, right? And there's just no similar mechanism to that under the Georgia Civil Procedure Act, right, in Georgia. And so
It's a little more old school. We'll just call up the docket and ask you if you're ready.
Yeah, exactly. And there are some exceptions. So like in some of the bigger cities, like around Atlanta, and I've seen it like Macon too. Like some of the judges are a little bit more proactive, and they'll have their, the judge's local rules in terms of, and the judge will enter orders to keep things moving along. But I'd say that's the exception, not the rule.
Right.
And the majority of the time, it's like what you said. It's basically just you have to do all the discovery you need, take all the depositions you need to take, do whatever other discovery stuff you need to do. And then basically once both sides have done everything they need to do to be ready for trial, you're just sitting on a list basically waiting. And the court will just have a list of oldest case on number one, newest case on the very bottom, and you're just waiting to make your way up to the top of that list to, so I know people, and I've been through it before too, where you've been like the cases, you've done all the discovery you need to do. Basically, everything is teed up and you're ready for trial, and both sides just have to sit there and wait for a year and a half, just while you're waiting for your turn to get a trial date.
Well, it creates a situation where it almost incentivizes the defendant to delay the case.
Yeah.
We haven't had a chance to do this, or we haven't had a chance to do that. And you're like, what are you talking about? I've been asking you for that deposition for, 4 months. Like, why are you telling the judge that we haven't had a chance to do it?
Right.
And you can get into a situation where if you don't have those deadlines in place, then I can tell you right now, like if we didn't have deadlines in place in Florida, there's a lot of defendants that would not just kind of sit back and wait for you to do something or, have the judge force them to do something.
Exactly. It just drags on forever. And so that's frustrating. And it's especially frustrating when I've had, not a ton, but over the years, I've had a handful of clients who I had a case with them in Florida and then had a case with them in Georgia. And, they're looking at me like, why everything moves so much faster on our Florida case? Why is the Georgia one taking so much longer? And I'm like, I swear it's not me. I'm doing everything I can. There's just, then I try to explain to them the difference between the way the procedure is.
That's frustrating.
It's frustrating. And it's also, like you said, though, it's like without any deadlines, the defense has no incentive to move things along at a good pace, and delays their friend. But also, like we always know, a lot of times, the threat of having that trial date coming up in the next 60 days or 90 days or 30 days or whatever is what finally puts the pressure on the insurance company to put their best offer on the table.
Right.
So the other thing you get in Georgia a lot of times, I feel like, is they're sitting back and, they'll maybe put some money on the table, but they're not going to put their best number out there until you wait and you're actually, looks like you actually might get a trial date coming up soon.
Yeah, think about it this way. The longer they hold on to their money, the longer they can have that money invested somewhere and make money on that money.
Exactly.
So the last thing they want to do is give you the money.
Right.
So if there's no deadlines, then there's no incentive for them to pay you. And you think about it this way. Like I've had, the good thing about Florida now is like we have the Supreme Court is like on these trial judges, and the trial judges will tell you when you're in front of them, they're like, look, I counted the days that you've had this case filed. Like we need to get this case tried. This case needs to be set for trial, or I'm going to have to answer to the Supreme Court as to why I have a case on my docket from 2019 or 2020 or something. And they are, they're on it, and they're on your butt to get these things off their docket. And sometimes you'll look at the deadlines and you'll say, man, these deadlines are really unreasonable. But these judges, they want to get these cases moved along, and they really force the parties to work together to get the depositions that you need, schedule the experts for compulsory medical examinations, schedule the experts for the depositions, make sure that experts are ready for trial. Because some of these judges, depending on who you're in front of, if you haven't done the things that they wanted you to do on their trial order, like I've had cases where the judge is like, well, you don't have an expert and you just disclosed this expert now. You were supposed to disclose him 3 months ago. You don't get an expert.
Right.
Well, guess what happens in that case? The insurance company is going to be paying you because they don't have a defense.
Right.
So those are the sort of things that move the cases along and can get a case off of a docket that otherwise wouldn't be off the docket if there weren't any deadlines.
Absolutely. Absolutely.
We kind of got off on a tangent there, but
Yeah.
it just, you start spitballing about some of the differences about Florida and Georgia, and we think we can make it better, but we'll leave that up to the legislators.
Sure. No, and I think what you're saying just kind of shows how something that sounds like maybe not that big of a deal in terms of like a kind of a seemingly minor part of civil procedure in Georgia can have such a big impact on just the way the cases flow, when they settle, how much they settle for. It's a lot more than meets the eye in terms of the impact these things have.
Absolutely.
No matter your injury, Nonni Homola is here to help you recover. Visit noho.law today.